Yes, we are live now. I'm going to begin just a second. Yes, so let's start today's webinar. First of all, thanks everyone for joining and um, for being there for the last 3 days. We've been having these amazing sessions, and today I'm very happy to tell everyone that we have Miss Sneha Priya, who has pursued Bachelor's of Civil Laws from University of Oxford. Just a second. Sorry. Yes. And she's currently working with Vidhi Center for Legal Policy Research. And she's been an amazing mooter throughout her law school. She's been a part of the team which was ranked 34th out of 640 law schools at Philip C. Jessup in 2017. Then she was also the runners-up in Philip C. Jessup India round, and she was also the best speaker in the finals of Philip C. Jessup in 2017. Apart from that, she's also done very well in trial advocacies, which is today's topic. So without wasting more time, first of all, welcome Sneha, and thank you so much for taking out your time.
Thank you so much, Anand, for having me.
Okay, so let's begin just a second. Sneha, can you, yeah, can you speak up a bit? I think your
Yeah, can you
voice
hear me?
is, yes,
Is
I can
that
hear you. Perfect. Yes, that's
okay?
perfect. That's perfect. Okay, so Sneha, when I graduated from NLU Odisha in 2016, till that time, trial advocacies weren't very famous and weren't that sought after by mooters as such. But today, you can see that there is a growing trend of students and of law schools who are organizing trial advocacy. So my first question is: this is for my own clarity, what is the difference between a trial advocacy and any other national or international moot court competition?
Right. So I think you very rightly pointed out that back in 2016, and in fact, I did my transparency competition happen in 2015, and back then there were only about 3 to 4 in a year, and it was just people were just trying to understand what this entire process was, and what such a competition included and what it actually meant. I think essential difference between a moot and a mock trial, I would call it. I mean, I would say there are essentially three differences. One is that mock trial advocacy kind of enunciates how a trial stage would happen. So how in a trial court you have witnesses, you have testimonies, you have analysis of experts, as opposed to a moot court where you actually are trying to argue at an appellate stage. So in an appellate stage you do not have witnesses; it is entirely based on your arguments. The
Yeah.
second difference, which is a very important difference and something that really draws everyone's attention, is essentially the demeanor of the participant. Now, in a moot court competition, it is slightly more formal. It's slightly more, you're more serious, and you know that you have to get to the point. You have one simple argument which you try to put forth before the judge. Whereas in a mock trial, there's a lot of conversationalism. There is a lot of exaggeration. You're trying to be more professional. At the same time, you're trying to play to the sympathies of the judge as well. So, to not sound too, informalistic, I would say that there's a slight addition of a lot of drama as well, because you have a lot of witnesses, you have cross-examination, you have a lot of intimidation that normally happens. I think this is what normally draws a lot of people towards wanting to try a mock trial competition. And the third
Mhm.
difference, which is also a very significant difference, is the role that a judge actually plays.
Okay.
Now, if you may have noticed, and especially for people who have done a lot of moots, a judge can interrupt at any point of time while you're arguing. So, you have to be ready to face any number of questions at any point of time. But
Hmm.
this normally does not happen in a mock trial competition because the judge
Okay.
actually allows the process to move forward and then comes in towards the end to ask you questions.
Okay. Got it. Got it. So that actually sounds very interesting, and uh, I found this out today itself that there's a difference in how the judges interact with the moot team members. So it's something really great to start this session with. So with a clear understanding of what trial advocacies are, let's move on to the next question, which is, when you chose to do a trial advocacy, what were the reasons behind it? And if a student is to choose a trial advocacy, what should that student see? Like, what should that student sort of think before choosing a trial advocacy?
Okay. To be very honest, I had done a few moots before having chosen this competition, but the only reason why I chose it was because I wanted to do something different. Now, essentially, I'm very interested in criminal law. So, when you're interested, you tend to read criminal procedure law, you tend to read the Indian Evidence Act. So, I
Hmm.
happened to chance upon, cross-examination of witnesses, re-examination, and other such terms, which I wanted to know more about. Now, this is
Okay.
essentially the most beautiful part of a mock trial, where you understand the concepts of, the IPC, the CRPC, and the Indian Evidence Act in a much
Hmm.
better manner. I think it's
Hmm.
always have theory by your side, but I think when you have, a practical experience of how all of these things work, it
Hmm.
really makes a huge difference in terms of understanding such concepts. So this is
Hmm.
one reason why I chose to do a mock trial, and this is absolutely the reason why people should go for it, because if you love criminal law and even if you don't like it, I think it is the
Hmm.
best platform for you to understand things in a practical sense.
Hmm. Actually, what I now think is that if at all if you're interested in mooting as such, or if you just want to become a good lawyer as such, then you should explore all available options, and one of them would be national moots, another would be international moots, and something apart from all of these, and something very different can be trial advocacies. So although I never got a chance to try out trial advocacies, it sounds really interesting. So I also have one question from what I was getting from your answers about the judges. Like, who are these judges? And because in national international moot court competitions, the judges are generally either people from law firms, or people who have when you go on to the semi-finals or final stage, there are judges of high court or supreme court. So in trial advocacies, what were the backgrounds of the judges which you encountered?
I can speak from my experience. So, in the preliminary rounds and the semi-final rounds, we had essentially lawyers who were practicing lawyers in the district court and the high court. So essentially, they know they know and they understand the process very well. But I think the
Hmm.
biggest challenge that I faced was in the finals when we had the high court judges. So these are essentially people who knew the process in and out. So you can't really mess with them when it comes to admissibility of evidence, when it comes to witness testimonies, analysis of expert statements. So I think the understanding of the law is very important. I wouldn't say that you necessarily have to be a lawyer or a judge or a certain person to be to be judging the rounds of national trial advocacy. I think what is important is to understand how the process works. So in this
Hmm.
way, I would say one of the most I think wonderful experiences that I had was in the finals when I had high court judges throwing questions left, right, and center about the process of how the criminal law works in reality, and I think that was very interesting.
Hmm. And what are these judges exactly looking for in a moot team? Like, apart from, of course, the advocacy skills, is there any other kind of skill which the judges are specifically looking for? From what I can expect is something like quick, answering quickly is something which the judges might be looking at. So, is there any kind of thing which you thought was there when you were participating?
Yes, absolutely. So the reason I think why judges don't really question you through the trial process is
Hmm.
because they're trying to understand your demeanor. I think the demeanor makes a really big difference in your marking scheme as well,
Hmm.
because it matters how confident you are. So essentially, you are cross-examining a witness. How flexible can you be? How well
Hmm.
can you change your statements when it comes to
Hmm.
trying to adhere to what the scenario is very important. Now,
Okay.
what I understood, from the judges that I faced was essentially that the law bit of it really is a very important part, but at the
Hmm.
same time, you should be able to understand the facts in question. That's
Okay.
because a mock trial competition involves too many facts, too many statements. So it's very important to brainstorm and try to create a sort of coordination between the facts and the law, and to bring a beautiful
Hmm.
story within.
Hmm. Now that we have started talking about the facts and laws involved, Can you tell me a bit about how the moot propositions, first of all, how do they look like and what do they contain exactly? And when you got hold of your first moot proposition, when you were participating in a trial advocacy, what was your strategy to proceed?
So I think the moot proposition when it comes to a mock trial is very, very different from something that you would normally expect. Again, you have facts which is again very different from a normal moot court competition, because here the facts also have to be admitted as evidence. Secondly, you have a lot of expert reports. Now, these expert reports are essentially medical reports. You have ballistic reports. You have the FIR, and you have witness testimonies. So these are things that are very unique to only mock trial competitions. And I wouldn't say there's a definite strategy, but I think what's important is to understand the law behind all of this. And for this, you need to be very, very thorough with the Indian evidence law as to, what can be admissible, what cannot be admissible. How does CRPC work? Procedure, very, very important. And again, very basic concepts of how, say for example, a medical expert would work, or how a ballistics report would be admissible or not. So there are very, these nitty-gritties that are involved. And like I said, your Bible would be the IPC, the CRPC, and the Indian Evidence Act. So you need to be extremely thorough with all of this to be able to understand the moot proposition firstly.
So the subject area of a moot proposition of a trial advocacy would always, revolve around criminal law. Is that so?
So ideally, as far as I know, in the Indian scenario, I have seen competitions which have only focused on criminal law. Just to give you another insight, my own college, in fact, my alma mater was responsible for having a international criminal trial advocacy competition.
Okay.
So this is essentially the ICC structure, but with witnesses, because the ICC also allows for the same. So I wouldn't say that it is restricted to only criminal law, but the trend in India has been that you normally deal with cases of murder, cases of these are normally things that are dealt with. But that's been my experience. I'm not sure, but ideally this is what I would say.
So what you're saying is mostly what you've seen is criminal law is the subject area which is focused on most in trial advocacy. So whoever is listening, if you want to try out trial advocacies, your go-to Bibles would be evidence law, procedural laws like CRPC, and then IPC. So if you have a good hold of them, then you can be confident about winning a trial advocacy moot. Okay, so this puts an end to our questions regarding moot propositions. Now let's come to the second stage of the trial advocacy, which is you're preparing your memorial. So first of all, how are they different from a national or international moot court memorial? And secondly, what strategies do you have? What tips do you have for students so that they can also use those when preparing a trial advocacy?
Right. So again, very surprisingly for my mock trial competition, we didn't have to submit a memo. So there are some competitions which also have this angle. So this is something that all of you have to also be aware of. However, I would say that a memorial plays a huge role in any competition. So even if it is not allowed for the competition, I think it's very important for you to create your own memorial, because it gives you a better perspective when you're actually arguing before the judges. So I think maybe three very distinct things that I, would suggest when it comes to memorial making. One is that since everyone knows there are too many facts involved, essentially there are as many loopholes as well. So one has to understand that this synergy between, the finding out loopholes and trying to put that out is very important in a memorial. The second important point is, again, being very precise. Now, say, for example, you're trying to prove that there's murder. It's very important to also prove each and every element of murder. Again, a clear coordination between the facts of the case and the law in question. So this is something that, of course, does exist in other memorials as well, but I think it has to be very precise. And I think the tune that, the facts and the law has to go together is very, very important in a mock trial competition. Now, the third and I think the most significant factor, which of course does not exist with the other two, is that all the facts that are present in the moot proposition have to be admitted as evidence in a mock trial. So, this does not exist with a national moot court competition or an international moot court competition. So essentially, this involves a lot of brainstorming, which has to be done between, what can be admissible. Say there's a video recording evidence. You have to prove that this is admissible before actually going more into it. So this is very, very distinct and a very important factor when it comes, to a mock trial competition memorial, especially.
Okay, got it. So basically, what you're saying is the trial advocacy which you participated in, there was no requirement of a memorial as such. But are you aware of any trial advocacy where you are supposed to submit any written document as such?
To be very honest, I felt that the competition that I participated was the only one that didn't have the submission because, the norm is that most competitions do have it, especially, the most popular ones. And I would definitely recommend that, you do have a memorial submission because I think it really puts your thoughts into perspective. And we
Got it.
also had a memo, which was, of course, it was only for our team, but I think it's very important to have one and make one.
Got it. So once, of course, like once a team is done with the preparing the memorial, then of course comes the oral round. So first of all, what are your tips for the oral round preparation even before going for the actual rounds? What do you suggest to the participants?
Right. So I think, again, trying to create a distinction when it comes to a moot court competition, you know your arguments, you have a set speech, you know what you're going to talk, you know what is going to be presented. But I think when it comes to a mock trial, you have to be susceptible to change. And I think that's a very, very important thing in terms of attitude. So, you have to be flexible because this is something that, I at least learned from my experiences that you cannot have a set speech, you cannot have a set strategy because it's never going to work that way. I will of course elucidate this for the discussion that we have as to how this really makes a difference. But I think it's very, very important to be understanding in terms of the fact that things can go haywire, and your perspective has to be very open and very flexible when it comes to dealing with oral arguments during a mock trial competition.
Got it. Got it. So, did your team prepare for the oral rounds before the oral rounds? Was there any kind of preparation which happened before the oral rounds?
Absolutely. I think one of the most important things for a mock trial competition is practice. And the reason I'm saying this is because you have witnesses and you have witness briefing that happens. So essentially, you're trying to teach your witness what he has to say, and when you cross-examine the witness of the opposite team, you'll have to break the witness, and this can only happen with practice.
I'm very sorry to interrupt you, but I'm only asking all of these questions because I am absolutely unaware about the procedure of any oral round which happens for a trial advocacy.
That's
So if you
absolutely
can,
fine.
yeah. So if you can just tell me in very simple terms how exactly the witness comes and how are you supposed to brief the witness before. So if you can tell me that, I would also know a bit about the oral rounds as such.
Okay. So what I'll do is I would actually call them different stages of the oral round. Now, the first stage that happens is the witness briefing, which is essentially the most important stage of the competition because this stage really makes a difference in terms of how the arguments can go. The second stage is, of course, the opening statements. Then you have the chief examination. You have the cross examination. Finally, you have the closing statements. Now, I'll just give you a little bit of insight into what exactly briefing the witness means. So what happens is each team is given a set of witnesses, which are essentially your witnesses that you train to answer your questions. Now, chief examination is nothing but you training your witnesses to answer your questions when the witness comes before the court. So this is very, very important because essentially the witness is someone who has absolutely no idea about what's happening. So you have to train them, in terms of what they have to answer, how they have to, put forward their answer, and how they have to deal with questions.
And
Now,
these
this is
witnesses are provided. I'm very sorry. These witnesses are provided by the organizing committee of the Moot.
yes,
Moot
absolutely, absolutely, and that's why it becomes very, very difficult because you have no control on these witnesses. You have no control on how they are. So essentially, you may get a witness, who's probably not so good at remembering. You may get a witness who's probably not so interested in what's happening. So these are some challenges that in fact we faced, where we had witnesses who forgot everything that I had briefed. I had witnesses who were not interested in what I was talking. So these challenges are essentially it is bad because it's not in your hands. You cannot help it because these are people you've got. But like I said, it's the most important part of the mock trial.
But so I'm sure that it's going to be challenging for the students when they have tough witnesses. But I think if you are able to sort of overcome that challenge, then it's a good indication that whenever you want to pursue litigation for a criminal side, then you might have those required skills, because even in daily real life, it's not given for sure that your witness would be 100% coherent with the facts, and he or she may be willing to remember everything. So I think, although it's challenging, but I'm sure that it might have helped you beyond law school as well.
No, I think what I would say is, in fact, I would call it the most beautiful learning of the mock trial competition, because I think if you have a set stage, and what's happening, and if everything's kind of scripted, it doesn't really make sense. If you're
True.
actually put on your toes, if you're put on your toes in terms of accepting challenges, it's always great. And like I said, mock trial competition actually gives you a perspective as to how real life litigation works. I wouldn't say it's the same thing, but I think it definitely preps you to, want to understand how it actually works.
I'm sure that it mimics the actual court trials more than any national or international moot
Absolutely.
court competition. So I think that's a plus point of having done a trial advocacy. So
Absolutely.
it sounds really exciting, and I'm very sad that I did not get to try trial advocacies during my law school. But anyway, so let's move on. So from what I understood about the procedure, first you have to brief the witnesses. Then you mentioned that there's some chief examination of the other witness from the other side, right?
No, so I'll just tell you this process
Ah,
again. So there is the opening statement. Now, opening statement is essentially a gist, or rather laying out the roadmap from your perspective for each side.
got it.
So say
Got
I'm the
it.
prosecution. You normally have 3 to 4 minutes of this entire process, where you're just going to put forward your case, saying that this is the background of the case, and this is how it's going to
Mhm.
be. Now,
Okay.
after this, you have something called the chief examination. Now, chief
Okay.
examination is where you're trying to establish your case. So essentially, you have
Okay.
your witnesses who come, and you're going to
Mhm.
ask them the questions which you have trained them for at an earlier stage, and they're just going
Mhm.
to answer your questions. Now, what
Okay.
normally happens, and this is variable in different competitions, is after chief examination, you have the cross examination. But this cross examination is done by the other team. So, after you've examined the
Oh.
witness, you have the opposite team that comes and tries to break the witness in terms of credibility, in terms of
Mhm.
veracity, and
Mhm.
that process occurs there, after which you have the closing statement. Now in the closing statement, you will try to establish what you've tried to prove during your cross
Mhm.
examination and chief examination, and you're trying to
Mhm.
finally put forward your entire case before the judge.
That was amazing. That gave me a complete understanding. Now I think I have the necessary knowledge to know like what trial advocacies are. Uh, so for the participants who are actually interested to do a trial advocacy, do you have any tips, first of all, for the chief examination, and second for the cross examination? I'm sure there are some kind of uh, tricks which you might have encountered during your trial advocacy.
Right. So I think so. What I would say is that there are certain objectives for both, which are very important, and I would want everyone to have a clear understanding of what it is. Now, when it comes to chief examination, you have to understand that you have to make the evidence admissible in court. So essentially, you're trying to establish that, say for example, it's a video recording, or say for example, it's a medical report. The point and the objective of the chief examination is to prove that this evidence is admissible. And the
Mhm.
second most important aspect is to prove that the witness is credible and the witness is persuasive. Now, since you've already trained the witness, what happens is that the witness essentially knows what he has to answer. For example, your questions would be to the tune of where were you on Monday, or where were you on that day, or what did you see? So these are questions that you've already trained the witness, and what the witness has to do is to essentially be persuasive and essentially prove that he's credible before the court. And I think the third most point, which is like, of course, the entire objective of criminal law in question, is that you have to prove that the offense has been committed, or the offense is proven beyond reasonable doubt.
Ah,
And these are the three main objectives when it comes to chief examination. Now, the same way, there are three objectives I would say for cross examination as well. The first one is essentially to prove or to test the veracity and the truth of the witness in question. So you're trying to break the witness, you're trying to break the credibility of the witness, you're trying to break into what the witness actually would say. So when you're the defense, or when you're the prosecution, when you're cross examining, you have to try to prove that what the witness is actually saying is false. So that is essentially trying to test the veracity of the statement. The second objective, I would say, is to try to establish the relationship and to try to prove that if you are false, then this would really be a problem. Now, say for example, if the witness in question is the mother or the father or the sister of the victim, it becomes very important to prove that the person is not truthful, or to break the veracity, because that really makes a huge difference in the case. And I would say the third one is to essentially expose the witness, to essentially shake the credibility of the witness, because that would really prove to the court that the witness doesn't hold any credibility and the case is actually fallen.
Got it. Got it. Got it. Okay, so I think I now have a complete understanding of how the moot proposition is to be dealt with, and how the oral rounds actually happen, and the various other things which you should keep in mind when you are preparing for the oral rounds. The next question which I have is, when you were preparing for your trial advocacy competitions, what was the kind of timeline which was there? Like, if you can, sort of give me a brief idea of how many months or how many weeks did you take to decode the moot proposition, and then after how many weeks did the oral rounds happen, so that we have an idea of approximately how many weeks are required to be invested in a trial advocacy?
Right. I think that, it again is a very subjective thing. It depends for different people. But I would like to talk about my experience. I think we had about 2.5 months for the preparation of our competition.
Okay.
And I think we took about easily 2 weeks to understand, how the moot proposition worked. And this is very important, especially if you haven't done a mock trial before. So, what we did was we tried to break down the problem. We tried to understand the nitty-gritties. We tried to understand the law as well, which is very, very important, because if you haven't really understood how the pre-trial procedure works, or how, the trial process works, it becomes very difficult to fit in all these, things like witness statements, things like expert statements, expert analysis. So these are terms that, for a layman is very different and very difficult to understand if you really haven't understood the law behind it. And so, like I said, we didn't have a memorial, but we decided to make one because I thought it would make a lot of sense to understand better. So we did have we had an internal deadline for the memorial, so we worked on the memorial for a month. But I think the most distinct part of a mock trial is the oral pleadings bit, and I think that can only happen with practice. So what we did was we practiced with multiple witnesses. So we had about 3 to 4 practices, and I think every practice makes you better because you get a different perspective. So what happens is normally, you cannot go into the mock trial with an understanding that, this is exactly how the witness is going to answer, or this is exactly, going to be the answer by the witness. So a lot of times what happens is you have the concept of hostile witnesses, which a lot of people do face. So it's all haywire. So you have to be able to, you have to be flexible to be able to understand that there could be different questions, different answers thrown. And that's essentially the only thing that is important, and this is where practice really, really makes a huge difference. And I think that was the case in our scenario.
Got it. And I know that you have also participated in competitions like Philip C. Jessup, and you have also participated in trial advocacies. So, what was the kind of time investment per day which you saw that like, what was the difference in the two competitions? Because uh, from what I can expect is that Jessup would definitely need a lot of time investment, and apart from that, you need to start preparing much before the moot proposition is actually released. So, what was your experience?
I think that so I would say that your team makes a huge difference in terms of how you deal with competitions in general. So I wouldn't say that I had to prepare. I mean, of course, Jessup did require much more scrutiny in terms of preparation, in terms of arguments as well. But I think I had an excellent team when it came to both the competitions. But in my mock trial advocacy competition, this sort of communication that you have with your co-speaker makes a huge difference, because essentially you have to understand that there has to be a synergy between the opening statement, the chief examination, the cross examination, the closing statement. So what happens is, if your co-speaker doesn't tend to really go with the synergy that you're supposed to be having, it becomes very difficult for you to continue. So, for example, I'll give you a simple experience that I had. My co-speaker was the one who did the cross-examination, and I was the one who did the closing statement. So, essentially, if he hasn't done well in cross-examination, it will become very difficult for me to really prove our case in question. So, this sort of communication between both the speakers, I think, is the most important factor when it comes to a mock trial, because you need to be understanding in terms of how both of you work. And like I said, there is no set speech. So, my closing statement was essentially something that was collated in the last minute, because I had to really deduce from the observations that my co-speaker had made. So I think that sort of coordination is very important when it comes to mock trial. Of course, Jessup has this entire different team communication, which is very important. But I would say that for me, I thought that what clicked and what had it going was the kind of chemistry that both the speakers should have when it comes to mock trials.
Got it. And what was the sort of evaluation criteria for the trial advocacy which you participated? And in general, what are the kind of things which the judges are looking for, apart from what you mentioned is demeanor? What are the other things which are also evaluated?
Right. So I think so. One of the things, of course, like I said, is your demeanor that really matters. But apart from that, what the judges really look for is your capability to be able to adjust to situations which are not going your way. Now, for example, when you go ahead with cross examination, the witness, you're not able to break the witness. You continuously try to ask questions, but the witness is still not budging. It becomes a little difficult in such a scenario. I think to be able to deal with it is what makes the real difference. Now, if you notice, in a moot court competition, there's a lot of law involved, but I would say in a mock trial, there's an equal amount of interplay between facts and law. And I think what a judge essentially is trying to look is how you're trying to create this sort of, tuning between the both and trying to present the best possible way of the same. Now, I would, one of the most, important things is that the witnesses are not really marked, and that's a very fair thing because you don't have any control over the witnesses. But I think it's very important that, they do really play a role, because, if you've got a great witness, things become easier for you. But if you haven't, then of course it is a little challenge, but I think how you come out of it really makes a difference. So some of the other pointers that the judges really looked at was the knowledge of law. And knowledge of law essentially comes towards the end when it is the closing statements, because that's when you try to, bring forward all the observations that you have made in the initial stages. And there might be a few questions asked at that point of time, so your capability of answering these questions. And the fourth one is which is I think the most important part, is to be able to be calm and composed during the entire process. So a lot of times people tend to get intimidated, tend to get intimidating. So you have to have that sort of presence of mind. Your calm and composure is the most important. Judges are not trying to look for aggressive speakers. They're not trying to look for people who are shouting or screaming. So this difference between aggression and assertion is something that judges are really looking forward to.
Okay, got it. That's actually a very good perspective. So yeah, I'm just trying to sort of give the students a holistic understanding of how trial advocacies would help them beyond law school. So if you have to sort of answer to this question, which is basically, do you think mooting and especially trial advocacies help beyond law school, and which is like this the help which I'm talking about is not just that you keep it on your CV or anything as such. Like, are there any skills which actually come to use after law school?
Right. So I think I'd actually pick it up from something very useful that you said at an earlier point of this discussion about how you should want to do everything when you're in law school when it comes to mooting. So, that is essentially the mindset that I entered with. I wanted to do an international moot. I wanted to do a trial advocacy competition. I wanted to do a national moot. So I think that it is very essential to do, to moot during law school. And when I'm saying this, it's not because of the pressure of, having a good job or pressure of CV, but merely for its experience. Now, a lot of my peers normally ask me why I don't debate or why I didn't participate in MUNs. And that is only for the simple reason that these are not exclusive to law school. So, you have, you've done this when you were in school, you've done this when you were in, a college. But essentially, mooting is exclusive to only law school. So essentially, if you haven't participated in those 5 years or in those 3 years of your law school, you've actually missed out a chance that you could have made use of. And when it comes to mooting really making a difference, I think it made all the difference to my life, because I think to be able to understand concepts in its real sense is what I understood. One. Second is, I think it really makes you confident. Having faced judges of incredible caliber, judges of great repute, is, I think, something that everyone should have to experience. And I think it makes you more confident as a lawyer, because we see movies and we see how scenes are depicted, and the reality is very, very different. It's not as dramatic as it is. So I think it really brings you to your place and tries to make you understand how things really work in the real world.
Yeah, and one of the points which you just said, that absolutely I can relate with, which is basically that you actually learn way more by participating in a moot court competition or in a trial advocacy, versus if you try to learn that subject in your law school. So that happens all the time. Whenever we get inquiries from students, they have this recurring question that if I haven't studied, let's say, international law, or if I haven't studied corporate law, should I do a moot on that? And we always tell them that you would be able to cover all your law school syllabus within weeks if you try to participate in a moot court competition. So kudos to you for saying for mentioning that advantage. Okay, so now I would be taking and I would be moderating a few questions from the students. So first of all, if any of the participants, if you have any questions, please write your question in the chat box. We would be taking them one by one. The first question is, can I get some ideas on leading questions?
Leading questions, again, very interesting aspect of the mock trial. So what happens is, I like to first talk about what leading questions are. Now, essentially, what happens is, these are a set of questions that directs the witness in a certain way. Now, I'll give you an example. Normally, these are not allowed, but there are certain exceptions to it. Now, what happens is, when the person, so say, for example, I am arguing and I have to do a chief examination, my question has to be very simple and precise. So I should be able to say, what did you see? Where did you see? And what is your name? So these are simple questions that have to be asked during chief examination. Now, what is a leading question? Now, leading question is something like, when you entered the room and when you looked at the right side of the room, did you see this? So essentially what you're doing is, you're actually leading the witness to answer in a particular way. So, this is not acceptable to the court, because you're essentially, the witness is not saying this out of what he's actually seen, but you're actually kind of helping the witness to answer in a way that you want to answer. So, that is not allowed, but there are certain exceptions to this. And these exceptions are, of course, mentioned in the Indian Evidence Act. And some of these exceptions are that, if it is absolutely relevant, the court will actually overrule that objection that, leading questions cannot be asked. But of course, like I said, leading questions are an absolute must when it comes to cross-examination, because that's when you try to kind of, shake the credibility of the witness, because you're trying to, test if they're actually telling the truth or not. So yeah, that's essentially my perspective on leading questions.
Got it. Okay, so the next question is, how will someone prove that the evidences are admissible? Now, on the top of my mind, what I can think of, you have to refer to the Evidence Act. But is there any other thing which you would like to substantiate?
No, so there is an entire procedure, in fact, that the Evidence Act mentions when it comes to understanding how, evidence is admissible or inadmissible in court. Now, say, for example, you have one set of it is witness testimonies, another set of it is ballistics report, you have the post-mortem report, you have the FIR. So, all of these evidences are not automatically admissible. You have to ensure that, you prove it to the court that they are admissible. And I think for this is an entirely legal question where you have to definitely go through the Indian Evidence Act. And in fact, I would suggest you, Anand, that again, more than happy to help you guys out with this, that you have a masterclass especially on understanding how to, deal with mock trial advocacy competitions from an Indian evidence perspective. Very, very beautifully discussed provisions. But again, very, very important to understand the process. And the reason I'm saying this is because I had a senior of mine in college who explained each and every provision to me one by one, to actually understand how this entire system works. And I think that's very, very important. And again, like I said, it's just a suggestion, but it's definitely something that everyone has to do if they have to understand how the process actually works.
Yeah, no, I think now we definitely need to have a class on that, because I can understand the importance of this this topic, which the amount that it would impact trial advocacy preparation. So I'm sure that a webinar on just the Evidence Act perspective on how the admissibility of evidence works, that would be very useful for the students. Okay, so the next question is from Siddhant. He is asking, will I be wrong to say if a weak witness is given to me, my case might fail?
Absolutely not. I think the beauty of it is that normally what happens is when it's a weak witness. So I'll give you a personal experience of ours. We had a witness who was absolutely just he just refused to listen to us because he felt he knew everything.
Okay.
So it was a huge challenge for us to actually tell him that this is what you have to remember, this is what you have to
Mhm.
understand. And he just refused to listen to any of it. And when it came to doing a chief examination of him, he actually forgot most of what we said. Now the beauty of it is that there is a reason for you to shine, because it's a challenge. But essentially, if you come out of it in the best possible way, it's the best way to impress a judge. So
Got it.
I would say that these challenges actually helped us during the process, because what happened is when he refused to answer the question, we tried to ask him more questions which he could try to connect to. And of course these are challenges that are always going to come during your preparation stage and not during your entire competition. But I think the beauty of it is to try to able to handle them. And I definitely would say that whether the witness is weak or strong would not make a difference in how the judge is going to understand you, because like I said, the witnesses are not, they are not scored at all. So it does not matter how bad they are, but how well you're able to deal with such a witness is what really makes the difference.
Got it. So from what I am understanding is that the judge would discount the fact that the witness is maybe not up to the mark if if the team member is trying their best to sort of examine the witness in the best possible manner.
Absolutely, absolutely. And that is precisely the reason why they're not scored. That the only role that they play is to try to help the case. But if they're really not doing that, it's not,
Mhm.
it's not going to be your fault. It's how you come out of it which really makes the difference.
Got it. Got it. Okay.
If
So
I may
Siddhika
actually,
is, yeah.
if I actually interject and add one more
Yeah.
point. Now,
Please, please.
the one good way to train your witnesses is to try different methods. Now what we did was we tried a quiz method, where what we did was we had a so that is one of the things that we did in our preparation stage. We prepared a quiz with like 4 questions and 4 options for each of them. And this is
Okay.
a very easy and a nice way of testing your witness. So you have a very limited time to really brief your witnesses. So your question has to be precise, your answer has to be precise, and they have to be able to understand it. So one of my
Hmm.
suggestions is to try to make the process easier for them. So I would say that whether a witness is strong or weak is something that you can also determine. So you can also make the process easier for them by making say questionnaires, by making short quizzes, by giving them slight tricks in terms of trying to remember things. And the reason I'm saying this is because, for an investigation officer, for a ballistics expert, for a medical expert, it is always going to be difficult because there are a lot of medical terms that are involved, which a person will not know, obviously. So
Yeah.
when you're going to try all these tips and tricks, it really definitely helps the process.
Hmm. That's good to know. That's, I hope that whose question was this? I hope Siddhant, you got the answer to the question and probably more to it than you were expecting. Okay, so Siddhika has a question. We've sort of dealt with this question, but if you can elaborate just a few more pointers on this, which is what what is the basis of the of selecting the winners in a trial advocacy?
Okay. I think one of the most something that's very obvious is that even before the judge actually scores you, you actually get a fair idea of whether you won or lost the case. Now this is something that's very
Okay.
very different from a moot court competition,
Yeah.
and simply by how you've dealt with the witnesses. If you're able to break the witness, if you're able to break the witness and break the credibility of the witness with a great cross examination, which I think is the most important aspect, if you won or lost the case. Very very simple. So what happens is that at the outset you can easily know if you won or not, and of course the judge will score you on the basis of that. But the most important thing is your cross examination, and if you can break that, then I think that's your make or break. In my opinion, that's where you determine whether you won or lost. And trust me, you will know whether you've got it or not.
That's another interesting difference between a moot court competition and a trial advocacy. So good to know. Okay, so Siddhant is asking how and what do we prepare before the proposition is released, and probably if you can tell from your own experience, we can also get to know more about it.
Right. So, like I said, before I wanted to participate in the mock trial competition, I wanted to have a fair understanding of of criminal law in general. So, how does an
Hmm.
FIR work? How does a recording of statements work? So, I would say that you need to have a thorough understanding of all of it, of all the CRPC, IPC, and the Indian Evidence Act. And not
Hmm.
just this. So, something that I personally did was back then when I did this mock trial, there were a few competitions that were already very popular, and it's
Hmm.
very important to understand how it kind of works. So what really helped me was to also look at the video recording of one such competition, which
Hmm.
really helped me to understand that okay, this is how it actually works, because
Hmm.
that there is a certain process. Like, assuming that each and every participant in this webinar has an idea, but I think it always helps when you see how it actually works, and I think that
Hmm.
really made a huge difference for me, at least.
That's actually good to know. Lippy is asking, and I also have the same question. What is the composition of a team and a trial advocacy?
I think that it is variable, but normally what happens is that, at least I can speak for myself, we had a three-member team. So you have two speakers and you have a researcher, and it depends on how you want to divide it. So you have four components. You have the opening statement, the chief examination, the cross examination, and closing statement. But I think the best sort of combination that you can have is your speaker number one, who has the opening statement and the cross examination. That is
Hmm.
stage number one and stage number three. And your
Okay.
second speaker, who has stage number two and stage number four, which is your chief
Okay.
examination and your closing statement. Now, having
Okay.
said this, having given you the suggestion, there are I must also warn all of you that a lot of times these competitions already have rules. So a lot of times they give you these rules that okay, this is how you're supposed to be. So assign you the roles. That also happens, but this is, I think, this is the best combination because you have a lot of time between each stage. So while your co-speakers out there, you have a lot of time to prepare for the next stage, and I think that really makes a huge difference.
Hmm. And do you think the roles, what do you think about the interchangeability of the roles? Because from my experience, when we participated in moot court competition, speaker number one used to be the speaker who had a good hold on, let's say, jurisdictional issues. So is there any kind of difference from moot courts in trial advocacies in this aspect?
I would say that, I mean, of course, this happens only if you have if you have a great communication with the team. Very honestly, my co speaker was excellent when it came to cross examination. So, this is something that we found out while we were practicing. So, you
Okay.
don't really know what you're good at until you're really out there doing it, right?
Yeah.
So,
Yeah.
my co speaker was excellent when it came to breaking down the witness. He was great when it came down to testing the credibility of the witness, testing the veracity. So that was our so we knew what strengths and weaknesses we had. So like you said, if speaker number one, if he's good at jurisdictional issues, you essentially send him. So we did the same thing. Our strategy was very simple. We had the all we had him who was great at that. And again, not to sound too repetitive, but the closing statement also is very important. And we had multiple practices, and we realized that I was better at trying to collate all the observations that he made. So in that way, we that sort of chemistry that you have is very important, and you will understand this only if you're practicing, and that's
Got it.
again why it's very important.
Got it. So from what I can understand is that while deciding what role should be assigned to whom, it's very important to do oral round practice, and through that, the team may be able to find out what a team member is good at or better at. So,
Absolutely. Like you said, don't restrict yourself, because I also did cross examination, and then we realized that I wasn't really, good at breaking the witness. So when you are very clear, and when you know out there that you're not so good at it, and you have your co-speaker who's better at it, then that's how you choose your role. It's very simple and straightforward.
got it, got it. Okay, so the next question is from Aditi. She's asking, if you don't have important, some important evidence which you are looking for in the proposition, then what should be your strategy? First of all, is there any clarification, procedure which is there in moot court competitions? When you can where you can send in clarification. Is there something similar in trial advocacy?
Yes, absolutely. So, in terms of how the competition is conducted, very, very similar to a moot court competition, you have opportunities of asking them clarifications. In fact, there are a lot of clarifications that they usually tend to give because, you have a lot of things involved, right? You have a lot of statements, you have a lot of, say reports. So
Hmm.
essentially, they do send a set of clarifications
Hmm.
always. But coming to the question in terms of what happens when you can't admit or what happens when it comes to evidence, I think what is important is there is an aspect to it. So now, for example, you have one aspect of it is the witnesses, and these witnesses could be eyewitnesses, which is
Hmm.
essentially ocular called ocular testimony in evidence law. So
Okay.
this is only one aspect of it. If you're not able to prove this, you have the second aspect, which is say medical witnesses or medical experts, say the doctor who's conducted the postmortem report. Again, plays a very important role in proving your case. Again, if this also doesn't work, you normally have the third aspect of it, which is a ballistics expert, someone who's working with firearms and guns, who can also
Hmm.
make a huge difference to your case. And if that
Okay.
also doesn't work, you have an investigation officer. So I would say that you are never at a situation where there is a lack of being able to prove evidence. So these are all
Hmm.
small aspects which together make your case stronger.
Got
And
it.
again, repeating that an investigation officer is the most important part of because he's essentially someone who's investigated the case until it has come to court. So it's very, very important to understand that all of these roles make up your case, and it's very important to be able to handle each one of them.
Got it. Got it. Okay. So next question is by Vanchika. She's asking, in what year of law should one try out trial advocacy? Now, like on the at the outset, I know that your answer would be that there is no such year. You can try it out at any given point of time. But with that being said, when you were participating in trial advocacy, what did you see? Like, what was the average year of the students who were participating?
I think again, like you said, my answer is that there is you should participate in trial advocacy competitions whenever you want, and that answer comes with my experience because it was entirely a mixed crowd. I had in one of my rounds I faced fifth years. In another round, I faced first year. So essentially, you see how different set of how you will be able to meet different set of people because I think when it comes to competitions like especially mock trial advocacy competitions, it's all about the experience. I'm assuming that people don't go out there with a notion that I have to do it in third year, fourth year, fifth year. It's all about how you will be able to meet different set of people, and like I said, it does not matter which year you are. It only matters is to whether you're interested at that point of time in doing it. But again, if you're going to ask me when you should do it, try to do it as soon as possible. I mean, you should try everything. So if this is something that is in your bucket list, maybe doing it as soon as possible is going to be a great experience.
Yeah, and also because what I personally think is, if you try it out at the earliest, then you can be sure of the fact if you want to take it forward or not. So
Absolutely.
exploring things at the earliest would make sense because then you can make more time for better things or the things you're interested once you're in your fifth year or fourth year. So who asked this question? Vanchika. Yeah, Vanchika, if whichever year you are in right now, you can try and aim at any trial advocacy, any upcoming trial advocacy. It's it's a good option at any given year of law. Okay, so Samrat has two questions. The first question is it a good idea to do a trial court internship before participating in a trial advocacy?
I think that I mean, this is irrespective of the irrespective of answering the question about trial advocacy competitions. I think every single person has to do a trial court internship
Hmm.
because what happens is that we tend to intern normally in the high court or the supreme court, and things are not really as fancy and as sorted down at the trial courts. And I think this experience and internship experience is very important irrespective of a trial advocacy competition. So I would
Hmm.
say that if you're going to be asking me this question, yes, definitely. But otherwise as well, again, just a general suggestion to each one who's watching this webinar, that you definitely have to do one trial court internship to understand the real nitty-gritties that are involved in litigation.
Mm-hmm. I'm sure that it's going to give you a very practical perspective of what you are going to expect in the trial advocacy.
Absolutely.
So it's definitely, yeah, I agree with you. His second question is there any source that can help us to understand the Evidence Act better? Now, of course, Samrat, we are definitely going to try to bring Sneha in for another masterclass on understanding the Evidence Act vis-a-vis trial advocacies. But on the top of your mind, do you have any resources which Samrat can go to and find out more about evidence?
Okay, right from my personal experience, yes, there were a lot of articles and a lot of pieces written on the importance of evidence in terms of competitions in general. But I would say that again, to reiterate what I mentioned earlier, very important to understand the process. Now it's very simple. To be very honest, I mean, now that I know, it might sound that me saying it's simple is very very
Mhm.
stupid. But then
Yeah.
the reality is that it's an entire process. It's like it's a stage. So if you know stage one, it becomes easier to understand stage two. Right on top of my mind, I do remember that from maybe sections 137 to maybe 164 of the Indian Evidence Act, every section is very important and they're all interconnected. So if you're going
Mhm.
to be understanding, and you can just start reading it like you're reading a story, because it is
Mhm.
really very very important to understand it in a layman's term. So I would say
Yeah.
that in the Indian Evidence Act is your Bible. There are a lot of things online, but I think you have to go back to the legislation to be able to understand it in the perfect way.
Got it. And actually, Mayank's question, which is the next question, is also sort of related to the previous question. Can you tell us some good commentaries, if you remember, on evidence and on IPC? I think Sarkar writes something on IPC,
Um,
if I'm not sure.
Yeah, so essentially, the more than commentaries, the way I actually understood IPC, CRPC, and
Mhm.
Indian Evidence Act was through cases. So I think
Okay.
that really made a huge difference. In fact, my experience speaks for it, because my the way I ended my closing statement in the mock trial, which really really impressed the judge, was I mean I made the statement which was part of a very very popular case. The statement goes this way. It says the witness can lie, but the circumstances have not, and that is how it proves my case. So essentially this
Okay.
was more like a dialogue. It was really a
Yeah.
dramatic dialogue, which was really good, because the judge actually felt like it was a mic drop situation. He was like, okay, this
Yeah.
really made a lot of sense. Like I said,
Mhm.
there is always a dramatic angle to mock trials.
Yeah.
And for me,
Yeah.
if you're going to be understanding, or if you want commentaries, I would say case laws are the best possible things that you
Okay.
should, because
Got it.
they make you understand facts, they make you understand how it really works.
Mhm.
And I would say that's how you should. But otherwise, you have R&D. I think R&D also has
Hmm.
it's been really helpful to me as well. But
Yeah.
I would say case laws are your go-to
Got
things.
it. Got it. Got it. And if anybody at this point is wondering about how those closing statement and opening statement, those customary lines, how should they be? Don't worry, we are going to ask Sneha to write something about this, or explain something about this in our upcoming course on oral argumentation. So if you are watching this webinar before 1st of July, be ready for a course which includes everything on oral argumentation for national, international, and trial advocacy. So that's actually one of my requests to Sneha. If you can help us out with understanding students, in making students understand where do these dialogues come from, so we can probably work together on this in the upcoming course. Okay, I think we're almost closing in with the questions. If anybody has more questions, please you can ask them right now. Otherwise, we would close the question answer session. The last question which is there right now is Vanchika is asking, can you please list some of the best trial advocacy competitions out there?
Okay. The ones that were there when I was there is all I remember, because I haven't really followed after that. But of course,
Mm-hmm.
everyone knows about the Surana and Surana Trial Advocacy competition. I think this is
Mm-hmm.
essentially the best best that's there in India, because they've been doing this for really long.
Yeah, even I
And
remember that it used to be there when we were doing moot court competition. So I remember it from that time.
Absolutely. And, just picking up from where I'd actually mentioned that, videos are very important. Surana actually puts up videos of all their competitions. So
Mm-hmm.
their trial advocacy competitions really gave me a lot of perspective when I watched it, because in one of the competitions, I had my seniors who won it. So,
Okay,
hearing it from their perspective is very different from actually watching them really do well.
got it,
So I
got
would
it.
say that irrespective of whether competitions are good or not, very very important to understand how the process works. I think
Hmm.
SVKM also existed when I was there. I participated
Hmm.
in NUSRL Ranchi's mock trial advocacy competition. It was very new when I did, but I think they're actually still having these competitions. So I guess it was a great experience for me as well. And KIIT Law School Bhubaneswar also conducts trial advocacy competitions, which were
Okay.
good. I had a team that went there, and they had a really good experience. So these are
Okay.
some, but I would say Surana and Surana is the best. Like, it's the undoubted best one.
Yeah, even from what I can remember, I know only one trial advocacy competition, that is Surana and Surana. So I'm sure the other competitions which you've mentioned would be helpful for Vanchika.
And if you're
So
interested, and just to add, if you're interested in international criminal trial advocacy competition, then you have SICTA, which is a very new thing, came over 3 years ago. But again, it's a
okay.
combination of your love for international law and trial advocacy. So that is something, if you want to really think of, you should definitely want to go.
Sorry, can you repeat the name of the
Uh,
international
yeah, so
criminal?
it is called SICTA. It's actually the Symbiosis International Criminal Trial Advocacy Competition. Again, the setup is
Okay.
similar to that of ICC, and
Okay.
purely people who are interested in international law with the trial advocacy process. It's a brilliant. I mean, again, I might be biased because it's my college, and
Hmm.
we were one of the few people. I was when I was part of the Moot Association, we came up with this concept. But
Hmm.
again,
Hmm.
the beauty of this is that there might be some people who are not interested in domestic law; they're interested in
Hmm.
international law, and I
Hmm.
think this gives a beautiful perspective on it. So if people are
Got it.
interested, it's a very good thing to look at.
Got it. Got it. Okay, we have another question. Please explain the relevance of medical jurisprudence with respect to trials. Okay.
Right.
Uh, yeah.
So yeah, medical jurisprudence really makes a huge difference, and I think that is one of also the fun parts of a trial advocacy competition. Something that you need to understand, causes of death, things that you normally will not also be doing. This is not something that is your forte essentially, because you're doing law, right? So something that I came across when I was studying medical jurisprudence is cause of death, cause of cuts. Understanding how a postmortem report works, what were abrasions, what are bruises. So I think that there are a lot of books in this, in terms of understanding how these terms also work. Like I said, I probably write something about sources which would help people understand how trial advocacy competitions work when it comes to law and when it comes to medical jurisprudence. But I think there's
Mhm.
Modi's medical jurisprudence, if I'm not wrong, brilliant book in terms of understanding all these basic concepts. Because these are concepts you will not understand even in law school, because you're not essentially going to learn them.
True.
But very, very important to understand this when you're talking about postmortem reports or when you're talking about medical experts.
Hmm. Got it. Actually, there is a demand for having more trial advocacy webinars. I'm sure that uh, we received a lot of new information in today's webinar. I'm not sure about of how much the participants were already knowing about trial advocacy. For me, it was a very informative webinar. I got to know a lot of things about trial advocacy. Okay, so just a second. Okay, so with that, I think the question answer session is coming to an end. Thank you so much, Sneha, for taking out time. I would request you to, give more time to us and to students whoever approaches you for trial advocacy. I'll tell you why. Because there's a dearth of people who have done well in trial advocacies who are willing to come up and speak about it. Because it was very difficult for you and me to find a person like you who's done well in trial advocacies and who's willing to come. So now that we know about you, we would want you to come at least a few more times so that the students who actually want to win trial advocacies they are benefited. So thank you
Ab-
so much. Yeah,
Absolutely, absolutely. And the thing is, mooting has always been the most, important part of my law school life. So if there's anything that brings me back to it, more than happy to help, and more than happy to train or try to, help out as many people as possible. So yes, absolutely open to any sort of, contribution that you would want from my side.
great, great. Thank you so much.
Yeah.
And with this, we are also coming to an end of our master class, which was on national, international, and trial advocacies. I hope that everyone has had a good time. Everybody understood more things, understood from the perspective of people who've actually done well, because that's also very important. Reading about it, watching videos that may not be always useful or always helpful. So I hope that people enjoyed it. I hope people learned something out of it, and we are going to have more of these sessions in the future. Welcome Samrat, welcome Siddhant, whoever is. Okay, Siddhant, if you have another inquiry, yeah, please go ahead and ask your question. If anybody of you have more questions to Sneha, what you can do is you can write to us at contact@memopundits.com, and we will forward your question to Sneha and see if she's available to answer to those questions. But yeah, nonetheless, thank you so much for answering so many questions about trial advocacy. And yeah, we hope to see you again very soon.
Thank you. Thank you so much, guys. Thanks, everyone.
All right. So
Yeah.
with this, I'm going to end the meeting. If anybody wants to watch this video again, or if anybody wants to forward this video to a friend, you can watch this video on our YouTube channel with the name of Memo Pundits. Thank you so much, guys. I hope to see all of you again and see Sneha with us again very, very soon. All right. Thank you so much.